Welcome back. I'm Stephen and this is episode 9 of the Ejaries.a podcast. We're approaching the end of the series. This episode is about one of the most difficult scenarios in the Ejaries landscape. What happens when a landlord refuses to register? This isn't the most common situation. Most landlords either register, Ejaries, or accept that the tenant will register on their behalf. But it happens often enough to be worth covering in detail, because when it happens, the tenant is in a difficult position and needs to know what their options actually are. How this situation arises. The standard pattern is this. A tenant signs a lease, they move in. They ask the landlord about Ejaries. The landlord says they'll handle it, or that it isn't necessary, or that they prefer not to register for reasons they may or may not explain. How this situation arises. The standard pattern is this. A tenant signs a lease, they move in. They ask the landlord about Ejaries. The landlord says they'll handle it, or that it isn't necessary, or that they prefer not to register for reasons they may or may not explain. Time passes. The tenant needs the Ejaries certificate for DEWA, or for a visa procedure, or for a child's school enrollment. The certificate isn't there. The tenant goes back to the landlord. The conversation doesn't go well. There are several variations on this. Some landlords genuinely don't understand the system and need to be walked through it. Some landlords understand it perfectly well, but want to avoid registration for tax or reporting reasons. Some landlords are willing to register, but only at terms different from the contract, for example, registering a lower rent than what was actually agreed. Each variation calls for a different response. Let's work through them. The unaware landlord. The simplest case is the landlord who genuinely doesn't realize that registering Ejaries is their legal responsibility, or who hasn't done it before and isn't sure how to ash. This is more common than people assume, particularly with individual landlords renting out a single property they own. They may have bought the property as an investment, never having been landlords before, and the operational details of tenancy management are unfamiliar. The fix is information. Walking the landlord through what Ejaries are, why they exist, what's required, and what happens if they aren't registered. Most landlords in this position, once they understand the picture, register without further friction. The tenant can offer to handle the registration themselves on the landlord's behalf, with the landlord providing the documents. Many landlords prefer this. The tenant pays the fee, does the legwork, and the registration completes. The unwilling landlord. The harder case is the landlord who understands the system perfectly and is deliberately avoiding registration. The reasons vary. Some landlords don't want their rental income on a government register that could be visible to tax authorities. Some don't want the property recorded as rented for reasons related to ownership disputes. Some are renting on a casual basis. That doesn't fit standard tenancy rules. In these cases, persuasion is unlikely to work. The landlord has chosen not to register and isn't going to be talked into it. The tenant's options here are limited, but not zero. The principal options are these. Register the Ejaries themselves, using the documents they have access to, with the landlord's identification on file from the contract. File a complaint with the Rental Dispute Settlement Centre, citing the landlord's failure to comply with their legal obligation. Initiate the Ejaries registration through a typing centre which has channels for cases where the landlord isn't cooperating. In some cases, the typing centre can process the registration with the documents the tenant holds, particularly if the contract itself contains the landlord's identification details and the title deed reference. The registration may flag for verification, but can usually be resolved. Whether registration fully requires landlord-side documents the tenant doesn't have, the Rental Dispute Settlement Centre is the formal recourse. The centre can compel the landlord to register, and ongoing landlord refusal can have legal consequences. The conditional landlord. A specific variation is the landlord who is willing to register, but only at terms different from the actual contract. Most commonly, they want to register a lower rent than what's actually being paid, to reduce their taxable income or for similar reasons. This is one of the most dangerous positions for a tenant. If the tenant agrees, the official record will show a lower rent than the tenant is actually paying. If the relationship later sours and a dispute arises, the official record is the document the system relies on. The tenant has limited ability to prove the higher actual payments. The dispute centre can sometimes accept evidence of actual payments where the bank record shows higher amounts than the registered rent, but this is the kind of evidentiary fight that takes months and isn't guaranteed to succeed. The honest advice is to refuse the conditional registration and insist on registration at the actual rent. The tenant has the leverage here because the landlord's failure to register at all is a legal breach. Pointing this out can change the conversation. If the landlord still refuses, the registration should still proceed. At the actual rent, even if that means using formal channels to force the registration. The Rental Dispute Settlement Center. The Rental Dispute Settlement Center, sometimes shortened to RDSC, is DEWA's tribunal for landlord-tenant disputes. It sits under the DEWA Land Department. It hears cases on rent increases, eviction, deposit disputes, contract breaches, and registration failures. A tenant who wants to compel a landlord to register can file a complaint with the center. The complaint sets out the facts, the legal basis, and the relief sought. The center will hear both sides. If the facts support the tenant's case, the center can order the landlord to register and may impose other consequences for the failure. The complication, which we touched on in episode 1, is that the center's jurisdiction depends on the existence of Ejaries. There's a question about whether the center can hear a case where the very issue is that Ejaries don't exist. In practice, the center does accept complaints about registration failures because the failure to register is itself the breach being challenged, but the procedural details can be involved. For tenants in this position, the practical sequence is usually to attempt the registration themselves first, file a complaint if that's not possible, and let the center's process compel the landlord into compliance. When a landlord refuses to register, the tenant's options narrow. But don't disappear, the system has formal recourse. It's slower than voluntary cooperation, but it's available. The interim problem. While all of this is being resolved, whether through information, persuasion, self-registration, or formal proceedings, the tenant still has the practical problem of needing Ejaries for downstream procedures. DEW may not connect without the certificate. The visa renewal may not proceed. The school enrollment may be in limbo. In some cases, there are interim workarounds. DEWA may accept alternative documentation for a temporary connection, as we discussed in episode 6. Schools may accept a tenancy contract. Another evidence of address pending the Ejari certificate. Immigration may grant an extension while documents are sorted. These workarounds aren't reliable and aren't standard. They depend on the specific procedure and on the discretion of the receiving authority. They shouldn't be planned around. The cleaner path is to resolve the Ejaries issue as quickly as possible, by whatever means works, and not to depend on workarounds for time-sensitive procedures. Preventive measures. The best response to landlord refusal is to make it unlikely in the first place. Before signing the contract, ask the landlord directly about Ejaries. Will they register, or do they expect the tenant to register on their behalf? Either answer is fine. The landlord's hesitation or evasion is the warning sign. Collect the documents you'll need at the time of signing. Title, deed copy, landlord identification, building information. This means that even if the landlord later becomes uncooperative, you have what you need to register yourself. Pay the registration fee promptly. Don't let the cost of the fee be a reason to delay. The friction of a delayed registration is much more expensive than the fee. If you're choosing between landlords or properties, weigh the cooperation factor. A slightly higher rent with a cooperative landlord is often a better deal than a slightly lower rent with a difficult one. What to take from this episode? Landlord refusal to register Ejaries is a real and recurring problem. The response depends on the underlying reason. For unaware landlords, information is usually enough. For unwilling landlords, the tenant has the option of registering themselves, filing a complaint with the Rental Dispute Settlement Center, or working through a typing center with the documents they have. Conditional registration. Landlord willing to register but at false terms should be refused. Insist on registration at the actual rent. The Rental Dispute Settlement Center is the formal recourse. Its process is slower than voluntary cooperation but available. The best response to landlord refusal is preventing it in the first place. Discuss Ejaries at signing. Collect documents at signing, and weigh cooperation as a factor in choosing between options. In the final episode of this series, we look at the closing of the tenancy, how Ejaries cancel at the end, what to do with the certificate, and the procedures that follow. Thanks for listening. The full transcript is at transcript.a. For Ejaries registration support, Ejaries.a is the operational service.